Hey everyone, it's Mr. Drake. We are going to begin our next unit, if you're one of my students, by taking a look at a very brief introduction to the judicial branch of the federal government. What this video is going to cover is the role the U.S. court system plays, especially compared to other judicial systems in other countries. We'll also talk about how the judiciary was created and why it was created in the manner that it was as far as its structure goes, and talk a little bit about the history of the Supreme Court of the United States. We're not going to go into a lot of specifics, but just look at some very broad picture trends that the court has undergone over the last couple of centuries. So with that in mind, let's go ahead and get started. One of the things that makes the American judicial system fairly unique compared to most other federal court systems or national court systems around the world is the concept of judicial review, which is the idea that the judicial branch can declare an act of Congress unconstitutional. So as a result, the U.S. Supreme Court has a very, very big hand in policy making compared to other countries' court systems, because any law passed by Congress, if it's challenged by somebody and it makes its way through the court system, the Supreme Court can have a say in that law's validity or constitutionality. They can strike it down, or they can uphold it, or depending on how they word their opinion, maybe they can even strengthen that law to a degree. Another very important facet of the American judiciary is the idea that it is independent. Judges are not elected, so they are free from political pressure. They're appointed by the president, they're not voted upon, and they can stay in that office as long as they would like to until they retire or, keel over in office. So, as a result, the judiciary is able to, speak their minds and go along with their consciences when they're making decisions. The judicial branch is outlined by Article 3 of the Constitution, which is one of the shortest articles in the original part of the U.S. Constitution. The part that talks about the court system says, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, and shall at stated times receive for their services a compensation," on and on and on. So there's not a lot of guidance here. The Constitution tells us there has to be a Supreme Court. They hold their offices during good behavior, which has been taken to mean they hold their office as long as they would like, so long as they're not impeached. And that Congress has the power to determine what the court system actually looks like. So they create a Supreme Court, as the Constitution said. It originally had 6 justices, now there's 9. And they created originally 13 district courts, one district court for each state, and district courts would hear cases pertaining to federal law, and then if they were appealed, they would make their way up to the Supreme Court. Today there are 94 district courts, 89 of them are in the 50 states, and then there are district courts for America's various territories, such as the Virgin Islands and Puerto Rico and Guam and so on. There are also 12 appeals court districts. You'll see a map of that here in just a minute. There are 11 appeals courts across the United States, and there's also a appeals court for District of Columbia, which is probably the most powerful of all the appeals courts because they hear cases involving things that have happened in D.C. So any lawsuit involving regulatory agencies or, interest groups and stuff will typically go to the D.C. Circuit. As promised, here's a map of the United States federal district courts and Court of Appeals districts. You see that states that do not have large populations are still districts unto themselves, just like the original 13 states were. And more populous states are divided up into 3, in some cases even 4 districts. Reference this map as we go through this unit if you're one of my students, because we'll be talking later about the setup and organization of the federal court system, and this is pertinent information for that. The second part of this video is just going to go through a very brief history of the Supreme Court of the United States. So the Supreme Court first convened in 1790, a year after the Constitution took effect and George Washington became president. As I already said, it had 6 justices. The Chief Justice was John Jay from New York, who was one of the authors of the Federalist Papers, along with Alexander Hamilton and James Madison. Just as a quick aside, John Roberts, the current Chief Justice, is the 17th Chief Justice. So there, haven't been too many over the course of American history when you consider we've had, 44 presidents, for example. Originally, the court just heard procedural matters and appeals from district courts, so they didn't have a big say in policy at that time. They didn't even really have a lot of prestige or gravitas in the national government. First few years they existed, they didn't even have a permanent building where they met. The Supreme Court building doesn't come until considerably later. But over time, the power of the Supreme Court increases, which is what we're going to look at now. The Supreme Court truly became powerful under the stewardship of the 4th Chief Justice, who was John Marshall. He served from 1801 to 1835, so the longest tenured of all Chief Justices of the Supreme Court. Under the Marshall Court, the court expanded its role, and it asserted the power of the federal government over the states. Expanding its role is referring primarily to judicial review, which it gained the power to do in the case of Marbury v. Madison in 1803, when the court declared a portion of the Judiciary Act of 1789 unconstitutional, thereby asserting its right to review acts of Congress and strike them down if they ran counter to the Constitution. In McCulloch v. Maryland and Gibbons v. Ogden, the power of the federal government over the states was expanded. In McCulloch v. Maryland, it denied the state of Maryland the right to tax the National Bank, which was headquartered in Baltimore, saying that the power to tax was the power to destroy, and states can't tax a federal entity. And in Gibbons versus Ogden, the federal government was given the explicit right to oversee interstate commerce. Just one interesting story about John Marshall. It's not 100% certain if this is true or not, but according to legend, in 1835 when he died, the Liberty Bell in Philadelphia was rung in his honor, and it was at that time that the bell cracked. So John Marshall is often kind of associated with that legend, that mysterious crack in the Liberty Bell, if you've ever seen it when you go to Philadelphia. So there's your little bit of trivia for the day. Marshall's successor, Roger Taney, is also notable, although for more infamous reasons. He began to roll back some of the government expansion that had happened under the Marshall Court, and that was no accident. Roger Taney was appointed by Andrew Jackson, who was a notable advocate of states' rights and a limited federal government when he was elected in the 1820s. Most notoriously, Roger Taney is associated with the case Dred Scott versus Sandford in 1857. A little background, if you're not familiar with the American history aspect of this. Dred Scott was a slave who obviously lives in the South originally, but he was taken over the course of several years to live in free states and territories with his master. And so when he was returned to the South and kind of put back into slavery, he sued for his freedom, saying that because he had lived in areas where slavery was legally banned by an 1820 act of Congress called the Missouri Compromise, he was therefore free. And the Taney court did not agree with Dred Scott's reasoning, saying that because Scott was a slave, he was not a citizen, and therefore did not even have the right to bring a suit in federal court. So the whole case was moot. They also said that it was unconstitutional for a state to deny someone their right to property, which essentially meant that you couldn't ban slavery anywhere, which ruled the Missouri Compromise unconstitutional. Now, this was thought to be a legal matter at the time, but this ends up being a major bone of contention between the North and the South, notably pro-slavery and anti-slavery factions, and this is going to be a cause, an indirect long-term cause, albeit, but a cause of the Civil War starting in 1861. In the years after the Civil War, and up until about World War II, the Supreme Court worried itself primarily with economic cases, looking at how much the government had the right to interfere in business. This is during the Industrial Revolution, so that is a major bone of contention. And so there were lots of decisions made, which we're not going to go into the nuts and bolts of here, but they dealt with, the government's regulation of interstate commerce and its use of the Commerce Clause and its constitutionality and how far they could go. The rights of minorities weren't really addressed, and they certainly weren't expanded. It was during this time that Plessy versus Ferguson was decided in 1896, which held that separate facilities for various races were constitutional so long as they were equal in caliber. So the 14th and 15th Amendment aren't truly addressed during this time, and it's not until much later that civil rights and civil liberties become something the court will address with any regularity at all. Oh, and by the way, that man in the picture there is William Howard Taft, who is the only man to be President of the United States and a Supreme Court Justice. He was appointed Chief Justice of the U.S. by Warren Harding and served in that post from 1921 to 1930. In the years after World War II, civil rights and civil liberties did become a major focus of the Supreme Court's work. That started under the stewardship of Earl Warren, who was Chief Justice from 1953 to 1969, and his first major case as Chief Justice was Brown versus Board of Education, and that was an opinion that he wrote, stating that separate facilities were in fact unequal and that schools should desegregate. He also expanded the rights of the accused in criminal proceedings in cases like Matt versus Ohio and Gideon versus Wainwright. And under Earl Warren's successor, Warren Burger, who served as Chief Justice from 1969 until 1986, the rights of women were expanded, especially and most notably through the case of Roe versus Wade, expanding the right to an abortion in the first trimester of pregnancy. So, again, this review of the history of the Supreme Court is not exhaustive. It's simply meant to be an outline, and it's something that, if you're one of my students, we're going to be going over in much more detail over the course of this unit. As always, feel free to ask if you have any questions. Cheers!